I've never seen anyone as a defense attorney, prosecutor, as a judge, come before me and say, you know what? My intent was to go out and drink to intoxication, get behind a car and kill somebody.
Barry Mitchell faces a third DWI felony, 2 to 10 years on the table. He's hoping for probation, but the state is pushing prison.
All right, court is calling 2025 CR 015559, State versus Barry Allen Mitchell. Can I have parties announce?
Espinoza for the state.
Jim Oltersdorf for Barry Mitchell.
And are you Mr. Mitchell?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Mitchell, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Right. Court will find that the state is in compliance with discovery. Mr. Mitchell, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Mhm.
All right, you're charged with driving while intoxicated third or more as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mitchell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Nope.
Anyone promised you anything other than the plea?
Nope.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Mhm.
Yes. Okay, according to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,200 fine. State opposes your application. This will run concurrently with 2025 CC 007232, and there's to be restitution to DPS in the amount of $60. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No.
State, any evidence?
Yes, Your Honor. Proceed off of State's Exhibit 1 and all attachments.
No objections. Your
All right, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Honor. Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes. If you
All
want to
right.
proceed with sentencing of the judge.
Anything you want to say on behalf of your client?
Judge, yes, thank you for the opportunity. I've had a real, I don't know, Mr. Mitchell is he's a very nice man. He's had a problem, even though he's had some VR problems with the interlock because he doesn't have a car. He has really needs to be told by the court that it's the law and we really need to proceed with that. I know you may have received some VRs at the beginning.
Mhm.
I was very pleased, and I'm very pleased to stand here and tell you that his latest one was, even though there's a bunch of them, that most of it were at the beginning when it was a rough road, and I was explaining that he needed to have it. And it would kind of go back and forth between the two types of interlock. But what I find to be most interesting is my interaction with his family. His daughter is one of the most educated, polite, professional young ladies. She lives in Atlanta, Georgia. I've spoken with her many times, and she's had contact with Barry, her father, to tell him, let's go ahead and resolve this. And that's why we kind of jumped the gun a little bit to be here today. He said waiting for a court date. Of course, he had another problem with the interlock, and that would have been getting him in jail. But that's the only problem I think he's got. I don't think he's gonna, I think if he's on probation, I think he'll do well. I mean, he doesn't seem to do anything of any other major league offenses as a criminal. I think that he's got some type of an alcohol issue. I know that his son lives in San Antonio. I've spoken to him once, but I'm actually most impressed with the daughter's involvement. She can't be here, and she has been right on top of things and understanding the law. And I don't know what she does, but whatever it is, it's something pretty important, I suspect. But she doesn't lord anything over anyone in that respect. But I just find my conversations with her to be, she's just a very polite person. And I think that if she was in this room today, she'd be telling you, I wish I could be in San Antonio. I wish I could be on top of my father. My father will listen to me, but I'm over there in Atlanta where I have to be, where that's where my work, my professional life is. That's what I've spoken to her about. I said, somebody's got to be here to handle him a little bit. And Barry doesn't have a whole lot of backup here other than the son. But I think that, you know, the first person you're looking at is a 1986 DWI, as the court can see.
Mhm.
He didn't get another one not too long ago. And of course, the MTR, I don't know any more of the results of that. I know there were a couple of problems with it. And then, of course, this was part of that. But I just don't see him as a kind of person that's going to go out, drink and drive and kill somebody. I mean, I don't know how else to put it. I think that if you, and I know you are a very strict person on probation, I wanted him to come and see you in court today, hear you speak and see how you do things. And I told him what to expect. And I think that if you're over him and you're the judge on his probation, and you tell him he has to have the interlock, whether he balks a little bit about it or not, that's been the only problem I've had, is he'll do what you tell him to say more than anybody. So I'm asking you to please consider giving him a chance. He was on the 80-by-second probation. Looks like he did pretty well for a long time. But I think he'll do fine. And he's old enough to know he's a veteran. He's not a lengthy period of time in the service. It's not a veteran issue, but I've talked to him about that. But I just think that, we're really asking you to really give Barry a chance at probation. I think he'll let him see what he can do with you. Okay.
Or any kind of rehabilitation or something.
Okay. All right, let me hear from the state.
Your Honor, we are opposed to the application. Mr. Mitchell was placed on probation for DWI second, which was reduced to a DWI in county court just almost 3 months to the day. When he picked up this new offense, it begs the question of whether Mr. Mitchell was operating a vehicle that was not installed with ignition interlock, as is a condition statutorily under DWI, or if he was operating and planning to violate by going high. I think Mr. Mitchell is a danger not only to the community, but frankly to himself, and I don't think his behavior has shown he will follow.
Thank you.
Could I add one more brief thing about
Sure.
in the state? I invite them to correct me, obviously, if I say anything misleading. I believe that the driving facts in this case are pretty slim. I mean, he's operating, But I don't believe he's doing anything of any type of danger. Is that correct, counsel? Is he just basically sitting in a car with it running or?
This vehicle, but
This,
Yeah.
The law states it is operation.
No, we're totally in agreement with that. That's the law, Judge, and he knows that. I've explained it. But the driving is not a dangerous situation.
All right.
That's all I was trying to make sure the judge
Sure.
saw, and I know you did. Thank you.
Oh, yes. All right, so here's the thing. The state is requesting that you go to prison. And the most they're requesting that you go to prison is for 5 years. This is what I believe your problem is, and if I'm wrong, somebody correct me. He cannot stay sober. And I don't know why it is that people don't realize that if you're going to drink, take the via bus. If you would have been drinking and just took the via bus, the most probably you would have ended up with, which is public intoxication. But you didn't. And I know people are saying, well, I don't, he won't kill anybody, but you never know. That's the problem. I have yet, and both of you can correct me if I'm wrong, I have yet to meet anybody who's charged with an intoxication manslaughter or some type of intoxication case where they injure somebody and kill somebody. I've never seen anyone as a defense attorney, prosecutor, as a judge come before me and say, you know what? My intent was to go out and drink to intoxication, get behind a car and kill somebody. You know what it is usually is? People crying, I'm so sorry, I didn't know, I never meant for any of this to happen. But this is what you need to consider, right? You have your daughter, right? You have your son.
I was a truck driver for 30 years too.
Mhm. And see, here's the thing about that. People are on the road and some of them are intoxicated and they're driving. And when they're driving and they're intoxicated, they can hit anybody. They can hit people's children. They can hit the grandmother and the grandmother ends up dying and she's just trying to enjoy her golden years, or he's trying to enjoy his golden years. So I do think you have a strong addiction. And I think the only way to solve that would be inpatient treatment. And when I say inpatient treatment, that will be inpatient treatment at safety or either felony drug court. That is the only way I will consider placing you on probation. So your choices are, you're going to do somebody's inpatient treatment, or if you don't want to do inpatient treatment, I'll sentence you to the 5 years.
Patient treatment.
All right. Probation. The court is going to sentence him to a $1,200 fine that will be probated. State, how long are you requesting for length of probation?
I guess. I'm sorry, Judge.
That's okay.
Maybe like 5/7.
Okay. So the court will sentence you to 5 years in the prison, suspended and probated for 7 years. There's to be regular reporting by Zoom or in person, regular random UAs. This will run concurrent with 2025 CC 007232. There's $60 restitution to DPS. Field visits 1 time per month until further notice. Proof of employment within 45 days of release. No employment as a home healthcare provider or with minors. DWI education course. DWI Live. The Impact Panel Live, I'm sorry, VIP Live. 2-year license suspension. There's going to be 200 hours community service restitution. There'll be 1 hour deducted for every sober support meeting. I'm going to order 20 sober meetings in 20 days upon release. There's going to be referral to felony drug court in custody. There's to be a TAP evaluation in custody. If not accepted into felony drug court, then he's gonna be going to safety. Probation, did I forget anything? Oh, ignition interlock.
Yeah, that's what I'm saying,
I'm sorry.
There's
you
gonna
saw-
be
you saw
ignition.
me.
Yeah, there's gonna be
Going.
ignition interlock for the full term. Is there anything else, probation?
Judge, did I hear him say that he didn't have a vehicle?
Do you have a vehicle? Well, the vehicle that you were driving or not driving or behind the wheel in this case, whose vehicle did that belong to?
That used to be my son's vehicle back then.
He needs to have ignition interlock full term on any vehicles he has access to. So if you're living with your son and your son has a vehicle,
Staying by myself.
Yeah, according to his daughter, Judge, he lives in a boarding house somewhere. We're trying to get a key to get it there. So,
well, we will see.
yes, sir.
And if for some reason, yeah, the probation discovers he has no access to vehicles, then I will consider changing that and it will be a portable monitoring device with an affidavit of non-driving. Is there anything else, probation? Anything else you need in order to be successful?
Really good chance right here.
All right.
Well,
Okay. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Remember last document I gave you, talked about.
mhm.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so we're off the record. Here's the thing. You know, back in the day, they used to have pastors, and you could get the pastor's speeches or their sermons, I should say, on albums. So my grandmother, my mom, they have a lot of albums with sermons by pastors. And there's one sermon that's on there where this guy, he would constantly call his mom when he would get in trouble, right? He would drink, call his mom would come down and bail him out. The last time he went into custody at the jail, he was just screaming and hollering, telling them, you know, I want my mom to come bail me out. And you know what the deputies told him? Don't you know? And he's like, no, what? They're like, the person you killed was your mom. So don't be that person where you're hollering for your children and you find out that you've been driving intoxicated. You understand?
Yes, ma'am.
All right, good luck to you.
Mhm. Thank you.
Thank you, Judge.
Welcome.
Judge, we received the medical records from the state. We're asking for continuance so that we have an opportunity to review those records and also to potentially subpoena the necessary witnesses and
All
prepare
right, so did you receive this from the state today?
today, Judge.
I don't think it's appropriate for you to have a motion for continuance because you said you were ready. The state didn't give you the documents, so why should the defense be filing a motion for continuance? Shouldn't it be the state?
Can person say?
Okay. All right, court is calling 2025 CR 005964 State versus Joshua Sutherland. The court is in receipt of a motion for continuance. It's the court's understanding that the motion for continuance is based upon evidence that was given to you today.
Yes, Your Honor.
And,
Medical records specifically of the complaining witness in this case.
and you're not ready to proceed until you reviewed those and had someone else to review?
Yes, Your Honor.
All right, so the request for a continuance is going to be charged to the state. And so how long is this going to take you, counsel?
I'd say about 3 weeks, Judge,
All right,
just so I have enough opportunity to get the business records affidavit filed.
all right, Ms. Ferguson. All right, if you guys will discuss with Ms. Ferguson, she's going to give you a jury trial date.
Yes, Judge.
And did you want to address?
Your Honor, we are amending the indictment by agreement. Would you like us to make those changes on the actual indictment?
No, since that are official documents, you'll just need to make it on the record.
Okay, yes, sir.
Sure. All right, the court is calling 2025 CR 011765 State versus Valina Paige. Could I have parties announced?
Bridget Garza for defense.
And are you Miss Paige?
Yes, ma'am.
All right, counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Miss Page, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, any changes to the indictment? Or are you proceeding on the offenses charged in the indictment?
You're not sitting as charged. Count two, the lesser included, count two, which is a misdemeanor, assault bodily injury of a family member. And the state would like to ask to amend that count to add bodily injury in front, to add bodily in front of injury, and to add the complainant's name, which is Warren Dunn. Additionally, we'd like to abandon the scratching manner and these.
All right. So who indicted this without putting the complainant's name in the count? Yeah, but I mean,
I know,
so who indicted this?
I don't have that information available.
Isn't it just easy to pull up?
It is, I just don't have access.
All right, so this is what I'm going to tell both parties. When you all said off the record that you wanted to, we can go off the record. When you said off the record that you, oh, you know what, we can stay on the record. When you all both said off the record, you know, we were amending part of the indictment. The court didn't think it was going to be a substantive amendment. I mean, if you have an indictment and it doesn't even list the complainant's name in count two, yeah, I don't feel comfortable going along with that, because that is truly a substantive change when you don't even have the person's name that is the complainant in it, whether it's in count one or count two.
Your Honor, if you'd like, we can redo the paperwork to be on count one, and we can go on to the lesser included count one, which does it with the better state.
All right. Then you all will need to just change, I think, page 2 of the stipulated.
Yes, sir.
All
Thank
right,
you.
thank
Judge.
you. All right, court is calling 2025 CR 012282 State versus Danny Rivas. Could I have parties announced for the record for the state?
Eric Baker for the defendant. Your Honor.
And are you Mr. Rivas?
Yes, ma'am.
All right, could we go off the record for a moment? Okay, so you better make sure you check on that.
Yes, ma'am.
All right.
You have things every time.
Okay, I was trying to make sure. All right, counsel, we're back on the record. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Reyes, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Rivas, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with unlawful possession of a firearm by a felon as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you. So here's the thing, you can't be late for court. You understand?
Yeah, they wouldn't take my parking,
I'm sorry, what?
they wouldn't take my parking, I parked down there every time I film and they wouldn't take my, so I had to drive around and try to
Here's the
find.
thing, I understand what you're saying, but court starts at 9, okay? All right, and You've been late before, so don't be late again, all right?
Right.
We're gonna reset your case. Your attorney is in another county in trial, okay? All right, Ms. Ferguson, I need Ibanez.
Yes, ma'am.
Give me a 2-week reset.
Yes, ma'am. On March 10th.
March when?
The 10th.
All right, so we're gonna have you brought back here on March 10th. Once you sign the reset form, you excuse. Thank you. All right, so we will, there are no other motions, correct?
This is not one for argument, Judge,
Okay.
but it's just,
Oh, sure.
but no, Your Honor.
How many more hours are you requesting? Because I have to put in
Yes,
the,
Judge, I would say 30 because we've still got
Okay.
to, we anticipate this one going.
All right, thank you.
Thanks.
You just make sure the clerk has that.
Yes, Your Honor.
All right, thank you.
Sorry,
That's it.
have a great day.
Oh, are you too? All right, on this case, where are we on discovery?
I believe discovery, it's quite substantial. I believe it's complete, but for the agreed blood discovery order. I talked to Ms. Galloway. She has no opposition to it. We are waiting for the state to make contact with the complainant in order to get involved. And sometimes this blood discovery order takes 45 to 60 days, Judge.
All right, Ms. Ferguson, I need a discovery date, 45 days, thanks, 8. Yes,
Grab my pen, Judge.
you're welcome. Just have a seat. Once you sign the reset form, you'll be excused. All right, thank you. Hello. So I believe you all are set for jury trial?
Yes, ma'am. We're here just to announce ready. I've conferred with the DA.
Okay. All right, we'll make sure you get your trial.
Okay,
All right, thank you.
is that today, Judge?
Yes.
Okay. Oh,
Thank you.
what time is the court gonna bring the jury in?
They're scheduled to come up at 11.
11? Okay, so I'm back by 11.
Yes. All right, thank you. All right. The state has tendered a dismissal in your case, so they'll give you a copy of it and you're excused. All right, thank you.
Thank you.
You're welcome. All right, the state has filed a dismissal for missing witness. Any objection to the court signing it?
No objection, Your Honor.
There you are.
Thank you, Judge.
Thank you. Hello. All right, the court is calling 2022 CR 2320, State of Texas versus Jashawn Steen. Can I have parties announced?
David McLean for the defense.
And are you Mr. Steen? Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jashawn Steen who was placed on community supervision in 2022 CR 2320 for the offense of felon in possession of a firearm on April 19, 2022 for a term of 10 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 18th day of April 2025 in Bexar County, Texas, the defendant, Deshaun Steen, committed the offense of evading arrest in violation of condition number 1.
How do you plead to that? True or not true?
That's true.
Violated condition number 4, in Bexar County, Texas, the defendant, Deshaun Steen, did then and there fail to report to the supervision officer as directed for the months of January 2024 through December 2024 in violation of condition number 4.
How do you plead to that?
That's true.
Violated condition number 4, in Bexar County, Texas, the defendant, Deshaun did then and there fail to report to the supervision officer as directed for the months of January 2023 through December 2023 in violation of condition number 4.
How do you plead to that?
State will waive the remaining alleged allegations.
Any objections? All right, did you understand by pleading true to violations 1, 4, and 4, the court could find it true, grant the motion, sentence you up to 6 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 4, and 4? The court will find 1, 4, and 4 true. Is there a proposed agreement?
I don't know, Your Honor, the state would be asking for revocation and sentencing to 6 years in the prison.
Your Honor, I've reviewed the report from probation. Probation is recommending ISF 2 in order to address Mr. Steen's cognitive issues and trying to get him to change the way he thinks. I've had an opportunity to confer with Mr. Steen about this matter. I know how seriously this court takes, especially the reporting requirements of probation. And I know he has not reported for almost 3 years now. I've explained that to Mr. Steen. What he's explained to me is that when he first began probation, there was a DWI or some sort of offense that had a warrant. He reported, probation said, we're not going to arrest for you now, but you know, you got to get this cleared up. He did not report again. He's expressed to me that at the time he was struggling with drug addiction. He has since gone through rehab on his own, through Northeast Rehabilitation Clinic in Arlington, Texas. He states to me that he is drug-free at this time. He's trying to improve his life. He knows that he messed up. He's got some time left on this probation that I think we could still help Mr. Steen become a productive member of the society, rather than just putting him into prison and institutionalizing. I'm asking the court to follow the recommendations from probation. And I know that's a big ask, but I think we've got enough time that we can do that. Put him on zero tolerance. If he violates again, obviously the underlying is still there. And we can address that if we have to. Speaking with Mr. Steen today, he is clear-eyed, he is clear-minded. I do not believe he has any drug issues at this time. That's from just 30 years of experience of dealing with it. I'm not a doctor, but that's just my humble opinion. I think he can do this still, Judge, and we'd ask you to continue.
All right, here's my question. Has he done anything on probation?
He is not, Judge. He is presently working and employed. He works for a construction company. He is a paver. And so he is actively employed and being productive. But because of these issues that he had with not reporting so long, he has not performed anything on probation. He's got an outstanding balance. I think it's over $3,000 right now, that is owed for his fees and court costs and those kind of things. I don't believe that there has been any kind of community services done either.
All right.
Looking at the court summary, Your Honor, it doesn't appear that community service was ordered. And I do see that there is an outstanding balance. The state would just add, with this probation looking at the requirements, it doesn't look like much was ordered, which we would urge shows the importance of reporting that. I mean, that's the biggest factor on this probation.
All right. Counsel, if you'll have him sign that. I just don't think you're appropriate for community supervision any longer. You've been on probation since 2022 and you haven't done anything. The only thing I have before me is that you pled true to an evading, which is a new offense, and you haven't reported.
I'm not looking for any sympathy. I'm just looking for understanding. At the moment, I wasn't in my right mind. That's why I turned myself in, you know, and I was trying to get my life right. I know I wasn't reporting because I thought when I tried to turn myself in, the MTR wasn't popping up. It is, as you can see, I don't know when it just recently had popped up. You know, they said I didn't have no MTR.
So did he turn himself in?
Yeah, it was not.
Oh, you're not under oath, so let me see.
Not showing nothing, so.
Anything I can see in the system, I see a report on 11/22, that was an arrest in me through offenses, so I'm not sure if that was when the NTR was, if it was showing up as a warrant, but I do see that the last time an arrest was made wasn't. after that arrest, it would have been prior to assignment.
All right, this is what the court is going to do. As previously stated, the court is finding 1, 4, and 4 true. The court will grant the motion. There is $1,500 fine, time and money to run concurrent. Court will sentence you to 2 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not that you are on community supervision. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. And I'll also recommend the therapeutic community.
Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
And I don't think he did any inpatient treatment.
Not,
Okay.
no,
All right,
didn't
thank
happen.
you.
Thank you, Your Honor.
Thank you. Good luck to you.
Thank you.
Final result. Probation revoked. Steen is sentenced to 2 years in prison, plus a $1,500 fine, with a recommendation for therapeutic treatment. Years of non-compliance turned a second chance into time behind bars. Like, share, comment, subscribe.
Who's next? Fifth one down, Ricky. Ricky Felt.
Yes. One other,
Good morning, Your Honor.
Morning. Do y'all have all of the discovery?
Well, Your Honor, to be honest, I don't know. I have not had the opportunity to see if we have everything and to review everything.
All right, Ms. Ferguson, I need a 30-day reset for discovery. And so you need to make sure you're on time. Court starts at 9, okay? All right, your reset date will be March 26th. Just have a seat and your attorney will bring the reset form to you.
Thank you, Your Honor.
Thank you. A $10,000 fine. Knowing that, do you still wish to plead true to violations 1 and 1?
Speak up. Yes.
Court will find 1 and 1 true. Is there a proposed agreement?
Judge, we don't have an agreement, but state is recommending revocation. This is the defendant's second MTR for the exact same offense that he committed while he was on deferred. And because of that, judge, we asking that we revoke the defendant and sentence him to 2 years, take from the Texas Department of Corrections.
Sorry, to what?
Texas Department of Corrections.
How many? I didn't hear you.
2 years.
2 years?
2 years.
Okay, yes.
And Your Honor, we do have an agreement. I apologize. The state, we were talking back and forth, and then when he wrote it out, I took the entire offer to my client, and we would ask that you please follow this agreement.
All right. Are you waiving your right to appeal?
Yes.
All right. The court will follow your agreement. The court will revoke, find you guilty, sentence you to 2 years in the prison, give you credit for any time served.
Thank you, Your Honor.
You're welcome. And there is to be a continued no contact order with Jasmine Romo. Could somebody tell me, was the restitution paid for $1,797.56? Did you pay restitution?
No.
No, Judge.
No, ma'am.
I don't think, no, Judge, it wasn't listed on the summary.
All right, there's to be restitution, and this was a part of your plea bargain agreement. There's to be restitution to Jasmine Romo in the amount of $1,797.56. Is there anything else with regards to sentencing?
Sentencing, no, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Judge.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, you better start making better decisions. Otherwise, you're going to be in and out of prison. You understand? All right, good luck to you.
Thank you, Your Honor.
All right, what's happening with this case?
Judge, we've conferred and we're going to be submitting an application for PTD. I'll have them fill it out today, so we need some time to let that process play out.
All right, Ms. Ferguson, I need a PTD date. All right, let me give you a date.
Sure.
All right, I'm gonna give you March 26th.
26th?
Yeah,
Okay.
once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Court is calling 2025 CR 014509 State versus Herman Mitchell. Could I have parties announced?
Brandon Brady for the state.
And Jonathan Alvarado for the defense.
And are you Mr. Mitchell?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mitchell, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Judge, we'll be proceeding on count one, but waiving the punishment now.
Any objection?
No objections.
Yes. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, your charge of possession of a controlled substance, penalty group 1 to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Mitchell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir. You know.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 4 years in the prison. The state is opposed to your application. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Not.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Judge, we offer state exhibit number 1 and all of its attachments.
No objections.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
No, Judge, we request appeal.
Are we proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
Judge, as you can tell, my client is elderly. He also has an elderly sister who he takes care of because she is having kidney failure and she has to receive dialysis and care daily. He is extremely worried about her health since he's been incarcerated. I think, Judge, reading the stipulations, you can tell that this was a very, I don't know what the word exactly is, but is a traffic stop for a bike riding without, I think it was without wiper on the sidewalk. He has taken responsibility for that. We're asking the court to grant his application for probation, and so that he can get back to treating his wife or his sister, as well as tending to his own care as well.
All right, state your post.
Judge, we are, please.
All right, thank you. All right. Mr. Mitchell, I'm going to give you a choice. These are your choices. You have no other choices. I can place you on probation. I will place you on probation for 4 years. Your underlying sentence will be 4 years, or I can sentence you to 2 years in the prison. Which do you prefer? All right, court will find you guilty. Court will sentence you into prison for 4 years, suspended and probated for 4 years. Regular reporting by Zoom or in person, regular random UAs. Do you receive SSI or no?
This mess.
All right, there's going to be proof of SSI within 45 days of release. There's to be no occupation as a home healthcare provider. So with regards to your sister, you can't receive money for that. You understand?
I don't expect no money for it. I just do it out to help them.
Okay,
Thank you, Judge.
sure. There's going to be field visits 1 time per month for 3 months. There's going to be sober support meetings. How old are you, sir?
I'm 68.
All right, there's going to be sober support meetings, 20 and 20 days. TAP evaluation out of custody. Follow recommendations, but we'll start with outpatient treatment. I'm going to order 200 hours of community service restitution. There's to be an hour deducted for every sober support meeting completed. Now, the home that you'll be residing in, are there any minors in that home?
No, just me and my sister.
All right, there's to be no unsupervised contact with minors. That may change once he's demonstrated his ability to maintain his sobriety.
Great, Judge.
Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. Here's the thing. It appears that you have a drug problem. You're going to have to address that. You're not going to be any good to your sister if you're constantly in and out of jail, or if your mind is clouded by illegal substances.
Correct.
Okay, all right, good luck to you, sir.
Thank you, Judge.
Thank you.
You're welcome. Hello, how's it going?
Good. I wore your LSU colors today.
Yeah, hey, I appreciate that. And I can't even believe the, there's another person that I watch in Japan who's a teacher there, but she speaks perfectly, I think she speaks perfect Japanese. I think her name is, it starts with a W.
It's impressive. I've met plenty of people that live there 10 years plus
Yeah.
and still didn't speak any Japanese.
I think it's Wama, yeah, I can't remember what the name of the city is, but it looks like a beautiful place to live. And she was driving in the snow and everything. All right, so what is happening with this case?
Judge, we were here in court early December, and at that time, Ms. Cantu had 2 cases. And that original case was dismissed, and so we're here on the second case. I don't know if you recall this or not, but she asked for a different attorney, and I think that she's hired John Young on this.
Yeah, well, the thing is that, I was trying to tell him that, they had charged me with a crime, and then,
Well, no. So here's the thing. If you've hired another attorney, then this attorney is no longer your attorney, and we have to. Ms. Ferguson, has John Young filed notice?
I just want to see if we can get a reset, get that straightened out. If
Okay.
John really is the attorney, then.
All right, Norma, you want to recall this for Thursday? Are you available for Thursday, counsel?
sir, is there any way that, cause I was gonna go to law library for all the motions. Is there any
No,
way that I
my
could-
understanding is that you have hired an attorney and that attorney is John Young.
Yes.
So we'll need to have him here because we don't have a notice of retained counsel on file.
Miss, could you also, take over your phone stuff?
Now, here's the thing, he can no longer tell me anything if you have another attorney. We're just trying to make sure that is the case.
Okay.
So, Norma, we'll recall this for the 26th. All right, thank you. All right, today is plea deadline date.
Yes, Judge, we don't have a plea. We've been tendered a plea, but Mr. Cordova wants a jury trial.
All right, Norma, I need a jury trial date. How long is this trial gonna last? All right, 2 days.
Do the April 28th.
All right, your jury trial date is gonna be April 28th, and you need to make sure that you're on time for court. You were late today. Starts at 9. Do you understand? All right, once you sign the reset form, you're excused. Your plea deadline date has expired. Court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes.
All right, just have a seat. They'll bring the reset form to you. And if y'all can make sure I have an acknowledgement of discovery if there's any new discovery. All right, so I'm doing great. So here's the thing. This court starts at 9 a.m. So you need to make sure that you're on time. I see that this is probably your first appearance here. So now you know where the court is located. You know how the traffic is and you know how the line is. So make sure you're on time, okay? Right, so where are we on discovery?
Judge, I believe discovery is complete. However, there are some companion misdemeanor cases that are associated with this. So Ms. Shaw and I have discussed a tentative plea offer that will be tendered in that setting. I just need to explain some of the things to the complainant.
Okay, so how much time are y'all requesting?
Between 3 days, I think the 30 days should pass.
30 days, 40 days?
I was gonna say 45 if the court will allow.
All right, Ms. Ferguson, I need a 45-day reset, please, and you can just put it for discovery. All right, we'll be back on April 9th, and if your attorney wants you here sooner, they'll let the court know. Once you sign the reset form, you're excused.
Thank you.
Thank you. All right, what is happening with this case?
So Judge, we are asking for one reset. We think there may need to be a motion to suppress heard, but I am in need of finding a witness that was the Uber driver on that day. And so I'm asking for 30 days for a reset, and then if we could set it for a contested motion to suppress, when I find that witness, I will know whether or not we need to go forward
All
on
right,
it.
I'll set it for discovery.
Okay.
And then if there needs to be a motion to suppress, we can always set it. Ms. Ferguson, I need a 30-day reset. All right, it's March 26th. You were late for court. Do not be late again, okay? All right, thank you. Just have a seat and your attorney will bring the reset form.
Thank you. Have a blessed day.
Oh, thank you. You too.
Thank you. A couple weeks ago, so I've been on this case since I believe mid-January to late January. This is my first setting on the case, but he has been in custody for a very long time. But he had at least one prior attorney during that
Okay,
time.
and so the reason why is because we were waiting for him to be restored to competency and now he's been restored.
That's correct. This is our first setting on the case.
Okay. Are you ready for trial?
Not today. Well, we were talking about setting it for trial. States made the initial offer. I haven't been able to relay it. There was some discussions that happened. I've not been able to relay the offer to my client. But I will be ready whenever we set it for trial.
All right, Ms. Ferguson. Mr. Wilkins, recall him for tomorrow so his attorney will have a chance to discuss things with him at that time. And maybe at that time, he'll understand the reason why it's been a while since he's been brought over.
Thank you, Judge.
All right.
Oh, Judge.
Oh, hi. Good afternoon. All right. So on this case, where are we on discovery?
Judge, we've received discovery. We've got an offer today from the state. There is quite a bit of discovery. I still need time to review it. We'd ask for a reset to give me time to finish discovery and also continue talks with the state with regard to the offer.
All right. How old are you?
17.
17? All right, Ms. Ferguson, set this for 60 days for a plea deadline date.
Hopefully third first.
No.
No, I'm sorry, yeah. The week after that.
Oh, yes, that's fine.
April 27th.
All right, April 27th will be your plea deadline date. Once you sign the reset form, you're excused.
Thank you, Judge.
All right, thank you. You're done with the flu? It seems like everybody has some kind of bug.
Oh, man, we're trying to keep it from coming back around.
Yeah. Isn't that song by Carole King? It will be coming back around again or something? All right, the court is calling 2023 CR 7832 State versus Christopher Suniga. Can I have parties announced?
Brandon Credit for the state. Brandon Lopez from Mr. Suniga.
And are you Mr. Suniga? Yes. Did you review the document entitled motion to?
Oh, Your Honor, I hate to interrupt. I was approaching the court on a reset, Your Honor. I indicated on the sheet that I turned
Oh,
in.
nobody told me that. So why are we requesting a reset?
Your Honor, I conferred with the state, and they gave us two offers. My client is requesting time to consider those offers and make a decision by
All
next
right,
setting.
how old are you?
41.
I'm sorry, what?
41.
All right, so that needs to be considered today. All right, so let me know when y'all are ready.
Thank you, Your Honor. Your Honor, if the court will indulge, he knows what he wants to do.
All right. All right, we're back on the record in 2023 CR 7832. Mr. Suniga, did you review the document entitled motion to revoke community supervision with your attorney? Did you understand it? Are you the same Christopher Michael Suniga who was placed on community supervision in 2023 CR 7832 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on December 11, 2023 for a term of 10 years? Is that you?
Yes.
All right, state.
Judge will be proceeding on a violation of condition number 41, specifically that on or about the 31st day of October 2025, in Travis County, Texas, the defendant Christopher Miguel Suniga is then and there failed to comply with the rules, regulations, or instructions of the Berry County Community Supervision First Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant was unsuccessfully discharged from the Austin Transitional Center in violation of condition number 41.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 41, I could find it true, grant the motion, sentence you to 10 years in prison and a $500 fine? Knowing that, do you still wish to plead true to violation of 41?
Yes.
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes, there's the proposed agreement is to revoke the defendant and sentence him to 2 years TBC.
That's our understanding, Your Honor.
All right, so has he done anything
Your Honor,
other than the inpatient treatment?
he did complete the safe plea.
All right.
Judge,
Yes.
we did, thank E. It looks like he actually went to say P 2 times, one for 294 days, once for 163. It was that second time in which he did not receive the residential aftercare. Other than that, Judge. That's it.
All right. Are you asking the court to follow this agreement?
I am, Your Honor.
Yes.
Are you waiving your right to appeal?
Thank you.
All right, the court will follow your agreement. The court will sentence you to 2 years in the prison, give you credit for any time served, credit for any successful inpatient treatment completion. And there is to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because I followed your recommendations for our attorneys and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. If you don't control your sobriety and just go to it second by second, minute by minute, hour by hour, you know what's going to end up happening? Either you're going to end up in prison for the rest of your life, or either somebody's going to have to identify your body. And I don't think you want any of those things. So when you're released from prison, you need to immediately go to a sober living house. They have transitional homes all over the city. If you can't find one, when you're released, I'm still here, you come here, I'll make sure that you get into one, okay? All right, good luck to you, sir. You're
Thank you,
welcome. You're welcome.
Final outcome: probation revoked and a 2-year prison sentence with credit for time served and treatment completed. The court's message is clear. Recovery is the only path forward. Like, share, comment, subscribe,